Hello, everyone. I want to welcome you to today's webinar. We will be starting in just a few minutes. We have a number of people who are still logging in. So I'm hoping that all of you can hear me, that are logged in. As noted previously, and we will go over this again, everyone is automatically muted. We are asking people to submit items through the chat questions section if you have any. And again, we will be starting soon, so bear with us. Thank you. Hello, everyone. Thank you for joining us today for our loss control webinar, which is being offered through IBANS and IBANB. We are very pleased to have two knowledgeable presenters with us today, Franco Cerulli of C3 Legal and Matt Davis of Westport. Before we get to the introductions, I would like to remind everyone that you are muted and therefore will only be able to send questions through the chat or questions feature. There will be opportunities throughout the presentation to submit your questions, and we hope to get to as many of them as possible. If we have not answered your question or you are taking part by phone, we ask that you share them with us by an email following the session. Since we are using a new platform to deliver this webinar, we also ask for everyone's patience as we move through the presentation. Our first presenter this afternoon is Matt Davis, Vice President and Claims Manager at Swiss Re Corporate Solutions in Kansas City, Missouri. He has 29 years of experience working in and for the insurance industry. He joined Swiss Re in 2004, where he has focused his attention on professional liability claims involving both insurance agents and lawyers throughout the United States and Canada. Matt earned his law degree from the University of Texas. Matt, welcome to the session, and I'm going to hand the reins over to you. Matt, you may need to unmute yourself in order for us to hear you.
All right. I think we've got that figured out. Good afternoon, everyone. Can you hear me, Debbie?
Yes, I can. Thank you.
All right. Terrific. Well, again, my name is Matthew Davis. It's terrific to be with you this afternoon. I wish I could be there in person, but, well, perhaps another year. As Debbie indicated, I've been doing this for some time. In fact, for the past 16 years, I've been devoting my professional time exclusively to agents E&O. So I know a bit about it. I've handled or worked on literally thousands of claims throughout Canada and the US. So I'm delighted to bring that experience to bear for you this afternoon. No pun intended with the slide. Let's go down one slide and I'll talk about the agenda for today briefly. I'll be touching on three different topics. First, Claims 101, where we're going to talk about how to make the best use of your E&O policy, and the flip side of that, how to avoid having it be completely useless to you. Next, we'll talk about the numbers. We'll look at data on claims experience and loss drivers, both across Canada and in particular in your region. Finally, we'll talk about some true stories. I'm going to be talking to you about actual claim scenarios that we've dealt with the names changed, just so nobody gets embarrassed. I should mention too, as the note indicates, there will be some test questions, so I encourage you to have a pen and paper handy so you can record your scores. There won't be any capture of your individual scores, but this is sort of a fun way to have all of you get to see what the entire group thinks is the answer to particular questions. Next slide, please. Starting out with Claims 101, as I indicated, we are going to start out, have some test questions. So let's jump to the next slide and dive right in. Those of you who attended this presentation a couple of years ago with Steve Ritter from Swiss Re heard more of a soup to nuts presentation, what I'm going to try and do is just focus on the specific areas where I've seen problems with E&O policy. So let's talk about this exam question number 1 and follow through the scenario with me. Let's say your agency has had calendar year E&O policies for several years, switching carriers every year just to get the best price. You also placed a homeowner's policy, again, calendar year, for your customer Bob Smith in November of 2018. One of Bob's guests slipped on his sidewalk the following year in December of 2019, sustaining serious injuries, and the carrier that the coverage is placed with, big insurance company, denies coverage in January of 2020, apparently because you may have forgotten to forward the premium to the carrier. At least that's what they're saying. And just now, your doorbell rings and you've been served with a lawsuit filed this week by your former customer, Bob Smith, alleging professional negligence on your part. So what's going to happen? Well, let's go to the next slide and find out. Debbie, would you pull up the poll online? So here are your options. To which of your many E&O carriers are you going to submit this claim? Is it 2018, the year your mistake allegedly occurred? How about 2019, the year Bob's clumsy guest fell on his sidewalk? Maybe it's 2020. That's the year big insurance company issued its denial letter. Or it could be 2021, the year you got sued for $5 million. So why don't you all take a moment and enter your answer? And Debbie, if it looks like we've received most of those responses, why don't we go ahead and look at how the crowd replied. Now, most of you, understandably, put 2018 because that's the year that your mistake allegedly occurred. But some people thought it was 2019. That's the year the actual loss or injury occurred. A few of you thought 2020 because that's when the denial was issued, and about 10% thought it's this year because that's when you got sued. Well, let's go to the next slide. And the one after that, you'll find that the answer actually is 2021. It's the year you got sued for $5 million, assuming that that's when you first got notice of the claim or error. Next slide, please. So why is that? Even though the occurrence, the error happened in 2018, professional liability policies typically are claims made, not occurrence policies. If you go look at your Westport policy, what you see below is the first paragraph of that policy. Coverage. The corporation does hereby agree to pay on behalf of the insured such loss sustained by reason of liability as respects claims first made against the insured during the policy period. And that last clause is the most important one. This coverage is for claims first made during the policy period. Next slide, please. Well, what could go wrong in this situation? Because I've indicated that we do have problems sometimes. Well, let's dive right into exam question number 2. Let's assume you actually learned about the denial and the reason for it, supposedly that you forgot to forward the premium from your customer in 2020 when big insurance issues its denial. You turn in the claim then to your 2018 E&O carrier when you made the mistake, and your 19 carrier because that's when the loss actually occurred. That's just to be on the safe side. But when you got sued this week in 2021, you turn the claim into your current carrier and your 2020 carrier just to be safe. So what's going to happen? Well, Debbie, let's go to the exam question and answers. And follow along on screen. Is it going to be 2018, the year you made the mistake, which you reported in 2020, 2019, because that's when the guest fell? Again, a 2020 report. Is it 2020 because that's the year you received the denial letter and reported this year? Is it 2021 because, again, this is the year you got sued for $5 million? And I just said a bit ago that that's when you would turn it in. Some people think it's always all of the above, so we have that as an option under E, or F, none of the above. So let's go ahead and fill out our responses in the online poll. And then Debbie, if we could go to the responses the group has given.
No one has responded at this moment.
I actually don't see the questions up. They may not be able to see the poll.
Okay, just give me 1 second here.
Meanwhile, you all get to double.
We are having one small technical difficulty. Just give me 1 more second, please, to launch. Unfortunately, I don't think that one is going to come up, Matt. I'll make sure that the question is operational.
I'll tell you what, let's just go to the next slide then, and we'll see what the answer is. You can grade your own paper. So as soon as you can, Debbie, if you can proceed to slide 11. That's right. The bad news is none of the above. You've paid premiums for 4 years of E&O coverage, and not one of those 4 carriers is going to cover this $5 million claim for you. How come? Let's go to the next slide and find out. For starters, we just discussed that this is a claims-made policy for claims first made against the insured during the policy period. So that's going to knock out the 18 and 19 policies because no claim had been made yet. You also have to look at the notice provision of your policy. And this language appears in the Westport policy. It says the insured shall give prompt notice to the corporation of any claim and any potential claims. It also says, I've underlined the important language, potential claims must be reported to the corporation during the policy period or any extended reporting period or tail period. Next page, please. You're going to find those terms defined in your policy. Claims first made means the insured has become aware of a claim or potential claim. Of course, in our scenario, you became aware of the potential claim in 2020 when your customer provided a copy of that denial letter to you. Now, not every denial or coverage letter from an underlying carrier is going to mean a potential claim. In this situation, that denial letter said the reason there's no coverage is your agency didn't forward the premium. So that's put you on notice. The term claim is defined pretty easy, legal process, suit, subpoena, demands, that sort of thing. But I've highlighted in yellow the meaning of the term potential claim. Again, the insured has become aware of a proceeding, event, or development which has resulted in or could in the future result in the institution of a claim. Next slide, please. So how did things go wrong for you? Well, the answer should be C. It should be 2020, but here's the problem. You learned or became aware of the potential claim in 2020, but if you look at the end, you'll see you didn't report it until 2021. What that means is your 2020 carrier is going to rely upon the fact that you didn't report that potential claim during the policy period. As for your 2021 carrier, they're going to make the point that You actually became aware of this claim back in 2020. So by not reporting the claim immediately to your carrier, or promptly, to use the term of the policy, that's how you wind up with no coverage for a $5 million claim. Next page, please. In general, what should be reported as a claim or potential claim? Well, the claim is pretty easy. Again, lawsuits, demand letters, verbal demands for money or for some action, written or verbal statements that, even if they don't make a demand, assert an error on the part of your agency. Subpoenas or document requests too should be reported, because typically that's a tip-off that some plaintiff's lawyer is looking at the file as a prelude to making a claim. Easy stuff. Next page, please. More subtle are these kinds of potential claims. If you know that your customer is in litigation with its carrier claiming coverage exists, you're probably going to want to report that as a potential claim, because there's a high likelihood that the agency is going to get drawn into that fight sooner or later, either by the carrier blaming it on you or the customer. If you get a request from a customer for assistance or advocacy in arguing with the carrier, again, the prudent thing to do is turn that in as a potential claim, because of the potential pitfalls that may exist with respect to you trying to take a coverage position on behalf of your customer. Last, any claim that you find worrisome. You know your customer best, you know the situation, and whether it's a red flag or a red light, or it's just keeping you up at night, you have that sixth sense about when a particular customer is not going to let an adverse claim outcome drop. In that case, please submit a potential claim. Next page, please. What else can go wrong? Well, let's look at policy language regarding your duties in addition to promptly notifying us of all claims and potential claims. In the Westport policy, it indicates that the corporation has the right to investigate, defend, and conduct settlement negotiations in any claim or suit. Now, there is a consent clause that gives you the right to consent to any settlement, but in the first place, it's your E&O carrier that gets to manage the investigation, defense, and negotiations. The flip side, it also makes clear that the insured shall not admit liability for or make any voluntary settlement or incur any costs or expenses in connection with any claim. So again, you can't just go and try and settle a claim on your own before turning it in or in lieu of turning it in. Next slide, please. What else could go wrong? Well, let's talk about exam question number 3. We'll change the facts a little. Upon reading the denial letter, you investigate, but you can't determine whether or not the premium actually got sent or forwarded to the carrier. You do know the customer had sent it to you, so it's not their fault. You talk to your law firm's attorney, and between you decide to try and persuade the carrier to pay the claim. You go back and forth for months, as such things tend to do, but no luck. You can't get it resolved. Meanwhile, you get some good news. You learn that, according to Bob Smith at least, the slip and fall probably wasn't that serious. It seems like the person's back on their feet. So you decide to apologize to your customer about all the delay and offer to try and get the claim settled within your deductible. Unfortunately, you haven't had any luck there either. Instead, you hear that doorbell ring. So let's go to the next page. Debbie, you think we've got the polls back up, or should we just march through?
I'm going to attempt to. Give me 1 second here, and we'll know very shortly.
There you go.
Yay!
What's the most sensible action on? Are you going to do nothing and figure it'll just go away? Maybe you should offer a bit more money. Maybe you should have your lawyer reply to the statement of claim and then report it to your E&O carrier. Or the boring option, just turn it into your E&O carrier right away. So take a moment and fill out your response. And then Debbie, as soon as you think we've got most responses, let's go ahead and show those responses. I think I'm having an effect. First of all, do nothing, it will go away. Believe it or not, I've had insureds do all four of these things. Some people just can't take any. I think Franco will confirm they never do. You can also offer a bit more money, but the problem with that is policy said you're not allowed to negotiate. You need to leave that to your carrier. You could just have your lawyer reply to the statement of claim, because that's the lawyer you want to use, and then report it to Westport. The problem is your carrier gets to pick the defense counsel too, and with good reason. As good as your local attorney is, he or she doesn't have the experience in handling E&O claims that our defense counsel do. So as soon as, by the way, I have a note there. Because if you waited in and started trying to handle it is probably. Next slide, please.
Matt, it's Debbie. Your sound is breaking up a little bit. I just thought you should be aware.
Okay, I'll try and lean in a little bit. Let's go to the next slide, please. And one more, please. I present this just because this exact scenario happened to us last week. We had a customer who tried to handle a claim within their deductible. They did not know, however, that there actually was a good argument to be made that the customer had failed as well. Therefore, a significant portion of the claim should have been borne by them. But because our insured didn't argue that, by the time they handed it over to us, the customer was no longer willing to even consider accepting any responsibility, and this is what got reported to the underwriters. The insured's actions have had a negative impact on what should have been a low-dollar settlement that has now blossomed into 3 times the actual damages, and it's going into litigation. None of this is what you want. So, next slide, please. How do you make the best use of your E&O policy? And analogizing to plaintiffs and claimants being bears, you have to be ready to use it. First of all, you have to timely report your claims and your potential claims. You can't make any admissions or settlement attempts because bears are notoriously lousy to try and negotiate with, as are plaintiffs in some cases. You need to preserve all documentation, and if you have any questions, by all means, please reach out to your broker or to Westport and talk to one of your claim handlers. Your brokers are excellent. They are very knowledgeable. They're a resource, as is your E&O carrier. And let's face it, by paying the premium for your policy, you've already paid for our advice. Please, by all means, take advantage of it. Let's move on to the next slide, please. The numbers, we're going to talk briefly about a data-driven look at claims, both in your region and across Canada. Let's jump to the first slide. In each of these, I'm going to present to you both the data we have from across Canada and then the data from your region. And I included all 3 of the maritime provinces because it gave us a little bit more data to deal with, and in our experience, you have a similar claim profile. That's the reason you see all 3. In looking at Canada first, you see a pretty consistent split, almost 50-50 between personal lines and commercial. You see much the same thing on the right-hand side in your region. In the most recent year, 2020, you do see that the number of commercial claims has gone up as a percentage, but I think that's primarily because of a drop in personal lines claims, specifically with respect to auto, because there's been a lot less driving, which drives down the number of accidents. But you also, in many cases, have seen carriers rebating premium. And because of that downward pressure on premium, there's less incentive for customers to have been shopping for other policies, and that in turn can produce mistakes. By the way, I would expect that to reverse as a trend this year as driving and premiums go back up. Next slide, please. Coverage. What type of coverage are errors committed on? Well, you see on the left very consistently, number 1 is auto, number 2 is homeowners, number 3 is commercial property, and so on. So over the 7-year period, the most numerous appears at the bottom. Looking over at your region, you see in 2020, as I mentioned a moment ago, auto claims are way down as a percentage of the whole. Homeowners claims have gone up more recently. Next slide, please. What transaction type? In other words, where in the chronology of the sales and servicing of the policy did your alleged error or omission occur? Well, you see here that renewals are number 1, then new business for new clients across Canada. Those two are just flipped for your region. New business for existing clients, and then midterm changes, customer inquiries, and cancellations round out the group, both across Canada and in your region. Next slide, please. What was the process step? In other words, what were you actually doing at the time of the alleged error or omission? Again, you're pretty similar to the country as a whole. The most common process step is making a recommendation of some sort. For example, a coverage or limit. Being in the process of renewing a policy or making midterm policy changes are numbers 2 and 3. Then you also see issuance of a policy, risk assessment, or in the case of your region, claims has actually dropped into the list as a loss driver. Next slide, please. Last, for a moment, we'll take a look at the error type. That is, what is the allegation about the mistake that was made? To fit it on one slide, first we'll look at Canada, then at your region. You see here that consistently failure to procure coverage is the number 1 driver. And what that means is simply there's no coverage in place for the loss in question. Second most common, sometimes it's generally covered, but a particular needed coverage is lacking. In other words, it wasn't recommended. Third, the limit in place was not enough to pay the entire claim. Fourth most common, information you provided to the carrier is inaccurate. And what's often happening here is the carrier has had to go ahead and pay the claim because of that inaccurate information. It's then going to turn around and demand that you compensate it for the payment it had to make because it wouldn't have issued the policy had it had the accurate picture. Fifth most common, errors in explaining the policy to the insured. For example, occupancy requirements in dwelling fire policies. Next slide, please. And here you see that you're pretty similar to the country as a whole with a little variation, including year-to-year changes. For example, if you look at 2015, you see a spike in failure to explain policy claims, which may relate, for example, to a change in automobile insurance law. So that's generally at a high level what's driving claims both across Canada and in your region specifically. So let's take a moment to dive into some claim examples. But before we do that, are there any questions about those first 2 sections, Debbie?
Yes, we had one question come in. The question is, what happens if the claim takes place on December 31st, and then we are not back in the office for a number of days due to the holiday?
If the claim is made on the 31st, you need to report it promptly. You don't necessarily have to get it in that night, but you do have to have it to us promptly.
That is the only question regarding the information presented so far.
Okay, terrific. Well, let's go on to the next slide and true stories. What can happen if you're not careful? I should mention again that these are all actual claims with the names changed to prevent embarrassment. Now, there aren't any from your specific provinces in particular, so you shouldn't recognize any claim scenarios. While most are from Canada, I did want to include a handful from the United States because the claim scenarios really help illustrate a point. And in fact, because the standard of proof is higher in most US jurisdictions, if a claimant can win a claim in the United States, it's almost certain to be a winner in Canada. So let's go to the first scenario. This is a commercial property situation labeled "He Who Hesitates," and sadly it's something we see a fair amount. Your agency has been placing coverage for this customer, Bob Smith, who gives you a lot of work and his trailer emporium for several years. Unfortunately, Bob's business has had a couple of severe wind and hail losses through no fault of his own, but each one did cost several $100,000. As a result, the carrier that the coverage is placed with, big insurance company, announced in October of 2019 that it is non-renewing this account. The policy expires at year end. So this is going to be a difficult placement given the loss history and something you need to jump right on. Well, let's go to the next slide and see what happens. You work on it periodically, but you haven't managed to find a market that will take this risk by the end of the year. It gets bumped to the back burner. You look at it occasionally, but you stress more and more over it until finally in July of 2020, a 2-day storm hits the region, dropping significant amounts of hail, much of it on your customer, Bob, and his trailers, buildings, signage, and fences. Again, an actual claim we've dealt with, and the damage totals more than $1.5 million. This is not a unique situation. It seems like when some of our insureds run into a problem, they almost bury their head in the sand. So far and away, the best approach with this kind of situation is to, number one, make sure that you have a good diary system. Number two, make sure that when you have an urgent task like this, that you address that problem first. If you have to, bring in other members of the agency or work with other colleagues and other agencies to try and find a market that you can place this customer with. Finally, don't let it fall off your radar screen, because that's how you wind up in the situation that this insured was in, facing a $1.5 million liability. Next slide, please. We talked about the fact that there have been a fair number of homeowners claims up in your region. In fact, the personal lines claims tend to be a little bit more numerous than the commercial ones. Again, a scenario we've seen plenty up there. A homeowner moves into assisted living and puts his home up for sale. The homeowner tells you, his broker, that he's moved and purchases coverage on his new residence. The problem is, you don't think to suggest moving coverage on that home from homeowners to a dwelling fire or vacancy policy. The good news is that the old home, the one he's left, is winterized while it's being sold. The water's turned off, the toilets and sinks are all drained, the drains are all sealed. So where's the E&O problem? Let's go to the next slide and find out. The problem is your customer has a very good neighbor who sees a tree that needs watering, so he kindly turns on the water to your house, your customer's house rather, and waters the tree. The problem is he did not think to turn the water back off. You know what happens, the temperature drops, a pipe breaks, and I believe this is an actual photo from the house in question. I got this from a colleague who worked on that claim file. The home flooded, ruining 3 floors of flooring, baseboards, walls, ceilings. A significant amount of damage was done. And this is true not just obviously because someone moves into a managed care facility, but we have it sometimes with vacation homes or cottages where your customer is only there periodically throughout the year. Some risk management tips: you need to know the difference between homeowners and dwelling fire or vacancy policies. In particular, because you need to be able to advise your customer, you need to know what may not be covered on these policies. For example, contents, vandalism, broken water pipes due to freezing, depending upon the specific policy language. You also need to know about some special requirements that the policy may impose. For example, that upon vacancy, the house must be kept at a minimum temperature. And again, because most customers are going to have no idea what the difference is between these coverages, you have to be able to explain the differences to them and do so to make sure that they don't slip up. Another error that we tend to see on vacation homes, what's the mailing address for premiums? Because you can't have the premium statement sent to that vacation home that's going to be vacant potentially 9 months out of the year. Other errors that we see on homeowners policy, application errors. For example, failure to reveal a vicious dog breed or a trampoline or some other item that's specifically addressed in the application. We've also seen situations where a home was under renovation, which is fine, but when it's under renovation, oftentimes that needs to be switched to a builder's risk policy. Sometimes that happens, but then it doesn't get switched back to a homeowner's policy upon completion. Next slide, please. Auto claims are something that, although not in 2020, you've seen a fair number of in your region. And the devil is in the details on those claims too, potentially. In this example, again, a real example with the names changed, on March 16, Bob Smith appears at your office, a little chagrined, to say that he had an accident 2 days before on March 14th in his new car, which isn't yet on the policy, and he hit a pedestrian who was getting off a bus. But Bob does tell you that he acquired the new car just 10 days prior, roughly, and shows you a bill dated March 5th, which the good news is within the 14-day period where you can actually get the car put on the policy, even though it wasn't at the time of the accident. You bring this to the carrier, big insurance company, and they agree to your request to backdate the policy change to that March 5 date and cover any losses. In June, Bob receives a demand letter from the pedestrian's attorney and tenders it to big insurance. So where's the E&O problem? Next slide, please. Well, here's what actually happened in that case. Come to find out, that March 5 document was not a bill of sale, it was a repair bill. The vehicle was actually purchased and delivered on February 24th, which is outside the 14-day window. The plaintiff had suffered catastrophic injuries, effectively rendering him a quadriplegic and other severe injuries. Big insurance company then files suit against your agency for the $1 million in policy limits that it had to pay on this claim. Fortunately, because there were other parties involved, we were able to settle for roughly half that amount. But that's still a $500,000 claim payment going on your record. The point here is your customers are doing their best to be straight with you, but you're the professional who needs to pay attention to the details. You need to read what's given to you carefully and make sure that the information you provide to the carrier is accurate. We also see auto claims involving, for example, failure to add a new driver. One of the best examples of that is a teenager that gets their driver's license. Another policy is cheaper. Beware, because those often contain lesser coverages in some ways. More and more, we're also hearing about people involved in the gig economy. By that I mean people driving for Uber or Lyft or doing food delivery services. And these facts are often revealed to our insured not during the course of an actual policy review at your office, because a lot of your customers are friends, family members, acquaintances. They'll make the point that they mentioned to you during casual conversation that Junior has just gotten their driver's license, or that a member of the family is now driving for Uber. and they're going to make the point that therefore they counted on you to advise them with respect to that new risk. Next slide, please. Here's one out of my backyard. This involves the Midnight Express, a party bus. And this is something that we're seeing a lot of, at least across the United States. I don't know if this has made its way up to Canada in any numbers. Your agency has provided $4 million in coverage for Bob Smith's primary business, which is turf, grass. But he's come up with this genius scheme to come up with a side business, the party bus. He asked you to get $1 million in commercial auto coverage, which you figure is probably going to be adequate. Next slide, please. Here's the sad truth of what happened, though. A 26-year-old single mother of an infant was on this party bus taking part in a bachelorette party. She was standing near the back door of the bus, which had been modified by the bus company to make it a party bus. She fell out on this stretch of highway that you see here in the picture, was actually run over at night by 3 vehicles, obviously killed. A significant lawsuit was filed. Come to find out that under applicable local Department of Transportation regulations, a vehicle of that sort needed $5 million in coverage, mandatory. When we settled this claim, it was for in excess of $1 million because the agency had taken on some burden to advise with respect to the appropriate coverage. We see a lot of claims, in fact, due to dabbling in an area the broker's not familiar with. Other examples of dabbling claims include the owner of a pilot or pilot of an airplane which didn't meet the qualifications required in the policy that you procured. We've seen situations where the broker failed to realize that a homeowner's policy that he or she procures for a coastal home, especially we see them in Florida and the Gulf of Mexico, that they don't include wind or flood coverage because those aren't issues where you do most of your operating. We've had a claim involving a yacht that was purchased by the customer of one of our insureds, which you can now find if you scuba dive on the bottom of the Gulf of Mexico. Come to find out that the policy our insured procured had a docking restriction, which limited coverage to 100 miles from the owner's address. And since our insured's customer resided in Indiana, there was no coverage for that sunken yacht down in the Gulf of Mexico. Again, the problem was they tried to place coverages that they weren't familiar with, either the subject matter or the specific location. Next slide, please. Farm coverages often include, let's go back just one if we can to number 39. Farm coverages often include what we've called the double dabble. In other words, both the location and the insured risk, the particular item, are outside your experience. Now, I will tell you, I am not an expert on farm coverage. I'm not remotely going to be able to teach you how to place farm coverage during this 1-hour chat. I do want to present this, though, just as an example of the number of questions and issues that could be presented by a particular risk that you are unfamiliar with. For example, you see on the left-hand side of the screen what looks like a wheat crop, which is being harvested, put in a truck. You see bags of the wheat, and then potentially that gets shipped off to market. The problem is there can be different coverages required for a crop that's in the field, harvested and stored on the property for more than a few weeks, or that's on the road to market. Did you address all those different risks? Farm personal property coverages include a number of different items that might be used in a farming operation, generally in 3 categories: farm machinery and equipment, livestock, and farm products like grain or silage. Did you have all of those covered properly? Look at the different structures on the right-hand side of the screen. You may have to have different coverages or scheduled coverages for those outbuildings, for the fences and so on. we've had claims involving those things. And when it comes to crops, if you have organic crops specifically, that may require a different coverage. If you have coverage for livestock, horses, for example, but one of them is a racehorse, you may need a specific vet coverage. My point being, again, not to try and teach you how to cover a farm, but there are a lot of moving parts, a lot of different issues that may be substantially different from the homeowners and commercial property coverage you typically place. But look at the middle of the screen and you see a youngster on an ATV. Now, Debbie, let's go to the next slide and talk about that. This is another situation we've dealt with. Again, your agency, working with Bob Smith, who owns a farm with farm equipment, has some ATVs. And he's told you these are used mostly on the property, but he also says he wants off-premises liability coverage just in case. What happened in our case is a CSR is talking to big insurance company, placing that coverage, and it occurs to them, hey, would the policy cost less because it is expensive if we drop that off-premises coverage? Big insurance company says, yes, that will reduce the price. And the CSR understood that they were driven just on the farm, so she had them take it off. And as we indicate here, the Smith's daughter goes out on that ATV, has 4 cousins on board, rolls the ATV and severely injures one. The demand in that case, because of severe burns to a leg caused by the muffler, $3 million. Now we're going to do one more final exam. What was the cost of that coverage? Debbie, let's go to the next slide and see if we can pull that up. And do we have a poll question for that? How much would that off-premises coverage have cost? How much did we save that customer by removing it? Go ahead and enter your response based on your experience. And then after a few seconds, Debbie, if you'd pull up the responses. About a third thought it was 17, about a third thought 100, 25%, $250. I probably would have thought it was C or D if I just answered this the way you are. In fact, the answer is A. $17 is how much got saved. $3 million is how much that claim is worth, at least according to the plaintiff's attorneys. There are 3 mistakes that I see here. First, the insured that we were dealing with didn't know farm coverages. Second, they didn't know ATV coverages. And probably the most serious mistake, they made a change, even a minor change, without consulting the customer who knew that he wanted off-premises coverage. Significant problem here. Next slide, please. We're going to talk about commercial property a little bit and what the carrier wants. I think we have time for another couple quick examples. So Bob Smith, who's brought you a lot of business over the years, has another side business. He wants to build a multi-family dwelling. Now, most of the time, this particular insured customer was doing single family homes, but decided to go bigger and do a multi-family dwelling. You get a quote from big insurance company that references a warranty that no gas heaters can be used. But those terms aren't sent to your customer, Bob Smith, nor discussed, and they certainly weren't signed. In other words, there was no signature on the warranty. The policy goes ahead and gets issued with that warranty in place. So can you guess what happens? Let's go to the next slide. Pretty predictable. A sizable fire ensues, which it turns out was caused by open flame heaters to dry the concrete. The carrier denies because that's a violation of the warranty on the policy. And Bob Smith, of course, denies knowing anything about a warranty. And in fairness, because you didn't provide the warranty to him, didn't get his signature, and you didn't explain it to him, he doesn't have any chance to avoid the risk and the complete lack of coverage for that apartment building is going to be on you. Again, this was a 7-figure settlement. It's also a great example of the disconnect that we see between the expectations of the customer and the carrier with you stuck in the middle. And I should mention this isn't just warranties. We also see endorsements that limit coverage. And sometimes they're referenced on the quote, but that full endorsement isn't attached. And that's something that the customer is going to rely upon you to notice and to explain to them. The last point, you can't assume that quotes from another carrier are necessarily going to duplicate the policy and coverages that you've been asked to replace. Next slide, please. One last general category that probably a lot of you are asked to work with from time to time, and that is grown-up toys. By that I mean RVs, all-terrain vehicles, boats, and motorcycles. A lot of these toys, as I've indicated on the earlier claim, have unique limitations with respect to them. I'll give you one example. We had a youth camp claim where our insured placed $1 million primary and $3 million umbrella for this new youth camp that had a big lake, tough to miss, and a dock. You know they're going to have watercraft. But the problem is our insured didn't notice that the umbrella policy excluded watercraft. Consequently, after the policy was bound, but before the policy was received by the customer, so no way for them to know this, 2 jet skis collided on the lake and a young woman lost her leg at the hip. She suffered medical bills of $1.5 million, future medical of $5.7 million, lost earning capacity of $1.7 million. Really a horrific claim for which there was no umbrella coverage. Now, the primary carrier did pay their $1 million, but as I've indicated, the damages were much higher than that. The problem being that there was a specific limitation with or exclusion with respect to that watercraft. Another recent claim that we've had that fits into this category, the customer of one of our insureds owned 2 boats, and again, had a $1 million primary and $2 million umbrella policy in place, but this time the umbrella applied to both boats because they'd been scheduled. The problem is a new boat got purchased, but it was only added to the primary by our insured. You know what happens, the owner's son and a friend went out on the boat, the new boat that is. The friend fell out, was struck in the head by the prop, and we are currently facing a $9 million demand. So attention to detail when you're dealing with more than one policy, especially with policies that might exclude particular risks, like RVs, like snowmobiles, like jet skis and wave runners. And there are also policies that will limit coverage, even though it will cover a boat, it limits the coverage to a particular length or horsepower. We also see those claims fairly routinely on larger bodies of water. So that's a pretty quick rundown on all the different kinds of claims we see. Obviously, we see a lot more besides that, but hopefully this has given you some inkling of where the pitfalls are and what kind of E&O claims you might face. Again, I want to emphasize to you that you're going to have questions. Don't just sit and stew about them. Immediately get help. Again, go to your broker and ask them questions, and in appropriate cases, they will send you on directly to us at your E&O carrier. We have very, very experienced claim handlers to help you out, to answer your questions, to indicate whether or not a particular matter needs to be submitted as a potential claim. And oftentimes, because of our expertise at dealing with bears, we're going to be able to proactively get you out of that situation or mitigate the damage by dealing with it early on. So again, please get these claims into our hands so we can turn around and get them into the hands of competent attorneys, excellent attorneys, I should say, like the one you're about to hear from. Debbie, any other questions at this point?
Yes, we had one come in a little earlier, so it's about a previous part of your presentation. The question is, would this be considered a potential claim? Robert called to advise of a fire at 52 Street, Jean Baptist, Hedgewick, on Saturday, January 9th, 2021. I asked if any injuries. He states no, as the apartment was vacant since September, as the apartment needs renovations and the last tenant was not paying on time, so they let him out of his lease, I guess. He said he had mentioned to her that the apartment was vacant, but I don't have any notes of that. I mentioned to him that I would have needed to advise WAD that building was vacant, and I don't have any notes that I called WAD or emailed WAD to advise. I did a hot transfer. He spoke with Benoit Parquet. He does not know if it is a total loss. He said that the upper part of the building was affected and that the floor fell into the below apartment due to the weight of the water from trying to put all of the flames out. So I think that was in reference to the one that showed the image of all the water.
Yeah, I think, so the general question is that a potential claim that should be reported?
Yes.
The answer to that, based on that, what I could hear of those facts, yes. We have a fair number of claim situations where the customer will call you, their broker, to describe a situation, and usually it's just on the phone, and ask you if that's something that should be turned in. The peril is that later on, as more, and you say no, obviously, that's how we get into trouble. Later on, more facts come out. Those aren't shared with you. You would have changed your response if you knew that additional information, but that's not given to you. And of course, your customer is going to claim in hindsight, well, I'm pretty sure I did share that with him. So number one, those verbal conversations, especially with no record, are going to be a problem. But I think 9 times out of 10, if not 10 times out of 10, you're going to want to err on the side of saying, I think you should submit that. The worst thing that happens is, it's within your deductible, or the carrier indicates that it's not covered. The problem is you don't want to be left in the situation where further investigation would have disclosed that there actually is a claim that needs to be timely turned in.
We have another question related to watercraft. This question says, we have a lot of land that 3 people are sharing and there is watercraft. Who might face a claim if something occurred? The owner of the watercraft? My knowledgeable lawyer that's here in the office is saying all of the above. So Matt, what's your response to that?
I'll defer to him, but yes, it's always all of the above, right? Look, the person that's going to be sued is oftentimes the one that has the most coverage available. That's what the plaintiff is going to go looking for. And if he has to go to a neighbor or the person driving the boat, the person who owned the boat, the person who serviced the boat, they're going to follow the money and maximize the recovery for that customer. Would you agree, Franco?
Yes, Matt, absolutely. And here, if there's a number of different pockets to go after, you can rest assured, especially if the claim is sizable, they will go after all that they can.
Yep.
It's easier to let parties out of litigation than it is to bring them in later. And every plaintiff counsel worth their salt knows that. So you can expect that.
So sue everybody and let the court sort it out. That's the approach.
Almost.
Well, Debbie, that's what I had to cover. I'm happy to sit back and listen to Frank.
Okay, well, thank you very much, Matt. I can see by the clock it's around 2:31. So as we switch over to the next presentation, why doesn't everyone have a quick 10-minute break? And we will see you back, if my computer is correct, at 2:41. Welcome back, everybody. At this time, I would like to now introduce Franco Turley of C3 Legal, who has presented for us previously during other loss control sessions. Franco has been in the practice of law since 1997, with admission to the bars of Nova Scotia and Alberta, Canada. He has a long-standing interest in insurance and commercial litigation, legal ethics, and professional responsibility. Presently, he lives in Nova Scotia and carries on an insurance litigation practice with C3 Legal Inc. in Halifax. Okay, so Franco, I'll let you take over.
Great, thanks, Debbie. For my portion of the talk, in my ongoing efforts to instill fear in brokers, I'm going to cover off a brief overview of some of the duties and relationships that arise out of those duties for brokers. I'll cover off some of the key foundational cases. Then I'll review some of the other the case law that we've seen, which kind of highlight the principles. And finally, I will conclude with some tips on what you can expect when dealing with an E&O claim. So first off, we look at the some of the duties that arise. And the first duty, of course, is the duty of good faith. The duty of good faith effectively is the duty to operate free from any conflicts of interest, not to have any other competing interests as you give advice to your customers. The duty also follows on, there's also the duty, of course, to follow the client's instructions. Make sure that you understand their needs, and the duty to act with reasonable confidence. The standard that's always measured against is the reasonable and prudent broker. What would a reasonable and prudent broker do? And that's the broker that has typical and what the level of knowledge and experience that would be expected in the industry in the ordinary case, the products that are available. And as we'll see, some of the laws as well that govern the customer's business. In general, these claims are framed in negligence, although as we'll see, that's not necessarily the case. It starts off as claims framed in negligence. Any negligence claim has 4 elements, and that is the duty of care, the standard of care, causation, and damages. The duty of care is the duty that is owed to the customer, and the court begins by considering whether or not a duty is owed. That the ability and the work that the broker has done is measured against the standard of care, and that goes back to the reasonable and prudent broker. What would a reasonable and prudent broker do? What did the broker in this case do that, or did the broker omit to do something that a reasonable and prudent broker would have done? Negligence cases also look at causation. If the broker did commit an error, did the error cause the damages? And then it looks at whether or not any damages resulted. So that is the first general type of claim. The other type of claim that we see is in negligent misrepresentation. In negligent misrepresentation essentially is making a statement that's misleading in a negligent way. That is, it comes in with a 5-part test. Starts with whether or not there is a special relationship. That is almost always made out. If there's a special relationship between the broker and it inquires if there's a special relationship between the plaintiff and the defendant, in this case, the broker and the customer. And as I say, that's almost always made out. It looks at whether there is an incorrect or a misleading statement. So was a statement made that was incorrect or misleading? It looks next at whether the statement was made negligent. Is that something that a reasonable and prudent broker would have said? Was there reasonable reliance on the statement? So in spite of any wrong or misleading statement, was the reliance on that statement reasonable in all of the circumstances? And the way that the case law expresses the last point is, was there detriment, in the sense of whether or not the customer suffered damages as a result of having relied on that statement. The last type of claim that we see is in breach of contract. And those are claims that rely on a contractual relationship between the broker and the customer. Often enough, those are the types of claims that we see where the broker fails to place a policy as instructed, or fails to identify coverages, despite the fact that that was what one of the things that they were retained to do. It looks at whether or not the contract as between the broker and customer was carried out. Very often, however, these amount to a contractual provision, whether it's implicit or not to be negligent. And so we're very often back looking at general negligence principles, even in breach of contract type claims. So to whom are these duties owed? Firstly, to the carrier. There are duties owed to the insured, being the customer, and then very often there's duties owed to third-party beneficiaries, where the insurance policy or the coverage that you're being asked to place is intended to benefit others. With respect to the duties owed to the insurer, strictly speaking, it starts with staying within the terms of the brokerage agreement. Collect the information that is required, assemble the documents that are required in order to place coverage, follow the underwriting guidelines and stay within the risk parameters, and generally to act within the best interests of the carrier. With regard to the duties owed to an insurer, there's obviously the duty to accurately disclose any risks and material information. That may require site visits, meetings and interviews with the customer. There's an obligation to satisfy the requests of underwriters. So obtain any information that they require, and not to place risks on or place coverage on unacceptable risks. Duties owed to clients. Those are the duties to ensure that all the exposures are covered and to make sure that the client is aware in writing of any gaps in coverage. And we'll see some of that in some of the example cases. Clearly, there's an obligation to understand what the customer needs, understand the customer's business, so that those risks can be identified and any gaps pointed out in writing, so that it doesn't come back as a surprise to them, and importantly for our purposes, as a claim against you. The key leading cases that govern in Canada claims against brokers are Fines, Flowers, and Fletcher against Manitoba Public Insurance. They are cited, as we'll see, in basically every case that we see in broker negligence. In Fines, Flowers, that involved a boiler failure where there was a loss of heat at a at a greenhouse, which happened during the winter. And as a result, there was a loss of crops. The insured had a long-standing relationship with the broker and had trusted the broker to provide what was described in the case as full coverage. That was, as it turned out, there was coverage only for accident and defect, and it excluded any damage as a result of the failure of water pumps. The insurer did offer a policy that would have covered the failure of water pumps, but the broker didn't tell the customer. So in the end, they were found liable. Full coverage, what the case does is it identifies those relationships where a broker is asked to provide a general advice as to what coverage should be required, without being asked to place any specific type of coverage. So, quote unquote, full coverage. In those cases, what the court said is that a broker has the obligation to inquire what's meant and to investigate all the types of risk that would require coverage, that could be mitigated by insurance, and to place those appropriate coverages. And where there are coverages that cannot be covered off by insurance, or risks that can't be covered off by insurance, to advise the customer accordingly. That is to be contrasted with cases where there is specific instruction to provide a particular type of coverage. If the relationship is such that the broker is not being asked to provide a general type of advice, but simply to place certain types of coverage, then the standard is lower. So that's Fines Flowers. Fletcher in Manitoba Public Insurance is it simply highlights the duty to provide coverages where they are available, and to advise of them and allow the customer to decline them if necessary. That case involved a motor vehicle accident where the other driver had insufficient coverage to cover the loss. At the time when coverage was placed, there was available to the broker's customer uninsured motorist coverage. And that was not put on, and the customer was not advised. And of course, the broker was held liable. And as I say, those are cases that are mentioned in virtually every broker negligence case that we see go to trial where there's a decision. They tend to set a high standard for our reasonable and prudent broker, especially with respect to the relationship with the insured. When we are looking at whether a duty of care exists, the courts look at the nature of the relationship between the broker and the client. Was it foreseeable that the client would rely on the broker? It looks at whether or not special knowledge is necessary in order to place the particular coverage. Was there reliance on any information provided by the broker? And under all of the circumstances, was it reasonable for the customer to rely on that information? It looks at whether or not whether the broker knew or ought to have known that the client would rely on the broker. The cases are clear that what's necessary is to take care that the customer understands what the broker is going to be providing in terms of service, and the broker should take steps to understand what is being asked of them. Are they being asked for general advice as to coverage? And if that's the case, then the broker will have an obligation to inform themselves of the types of risks that a client is facing, and ensure that those are all covered off, or that the customer is advised as to where there are gaps, because the court will not shy away from attributing liability in cases where that is not done. If specific coverages are requested, there has to be reasonable skill in placing the coverage and to inform if that isn't available. As I've said, if it's a matter of full coverage where a broker is asked to provide general insurance coverage for a particular business, there's a high burden on the broker to inform himself or herself about the business of the insured. So it will require site visits, meetings, where the broker is going to have to inquire, learn the business, and to provide appropriate advice. As we'll see, there may be a necessity to get experts advice as well. It's one of the cases that we'll look at will show. In Fletcher, where a particular coverage was available and not made known to the customer, the court stated that it's entirely appropriate to hold private insurers to a stringent duty to provide information and advice. So the first case that we'll look at is called Monks and Farmers Insurance. And that was a matter where a homeowner had bought a property for insurance on a property for a log home. The customer had some renovations done, and the renovations caused some significant damage. Essentially, there was water damage to the insides of the walls, to carpets, to windows, which ended up costing a significant amount of money to clean up. The insurer denied liability under an exclusion, under one of the exclusions, and the broker sued, or rather the homeowner sued the broker and the insurer. The homeowner rather sued the broker for failing to properly advise the homeowners about the cause of action against the insurer. That is, the insurer denied coverage, and because of the passage of time, the homeowner no longer had the ability to challenge the insurer on its denial of coverage. And so they brought an action against the broker for failing to advise the customer that in the case of a denial, they did have the opportunity, they had the right to have that looked at by counsel. Both the broker and the insurer brought a summary judgment motion, which is a proceeding in court which is used to put an early end to litigation based on affidavit evidence instead of having a full trial. The basis of the motion was whether or not the damage fell under the exclusion. If the damage did fall under the exclusion, because there would be no cause of action against the insurer, the broker would also be out. On the other hand, if the court found that there was coverage under the policy, then the broker would have been liable for failing to advise the customer to get independent legal, or to get legal advice as to whether or not it had a cause of action against the insurer. At the initial motion, the damage was found to be excluded. Now that result was appealed, and it was reversed on appeal. The matter did go on to litigation, and it was settled on terms which we don't know. So what do we take away from it? Where there is a denial of coverage, it's tempting to simply walk away. It becomes a matter that where it's tempting to sort of ignore it and hope that the whole thing goes away. If there's a denial of coverage, though, those denials are sometimes made in error. And so it's worthwhile to ensure that you tell the customer that they should get legal advice on whether or not that denial was proper. The failure to do so could expose the broker to money. Our next case is Corrigan against Crane and Shuley. Corrigan was a matter where a plaintiff farmer purchased a tarp barn for hay storage during winter. And so the farmer had a broker provide a coverage for it, and it was put on as an outbuilding for named perils. As luck would have it, the building collapsed in December of 2012. The collapse was looked at by an adjuster. The adjuster went out and attributed it to a snow load. Now that was just on the opinion of the adjuster. There was no expert evidence that was obtained to confirm that, and because of the snow load, which fell within the exclusion, coverage was denied. So the insurer through the adjuster advised the plaintiff's wife that there was no coverage. Plaintiff customer called the broker, irate, understandably saying that this is what's transpired. The insured plaintiff or customer didn't submit any proof of loss, didn't take any action against the insurer, just allowed that coverage decision to stand. After some time, they sued the broker. At that point, the broker applied for summary judgment, hoping to have the claim dismissed without the need of a trial. At the summary judgment motion, there was no expert evidence as to the cause of the collapse. What the broker did is responded saying that that collapse could equally have been caused by a design flaw, wind damage, construction, all of which would have been covered by the policy. But because there was no expert evidence as to the cause, fortunately, the court couldn't find, in this case, that the broker had breached its duty of care. You see from the decision that there were several failures, though, on the part of the broker, and this is commented upon specifically at the motion hearing. What the judge said is, I'm satisfied that the defendant breached its duty to advise the plaintiff. Stated in Fletcher, private insurance brokers are more than just mere salespeople. There is no evidence before me to establish that any analysis was done with respect to Mr. Corrigan's request for insurance, that any advice was provided to Mr. Corrigan on the insurance that he was being provided, or that any advice was provided to him on foreseeable risks that could not be insured. On the contrary, the evidence is that of Mr. Corrigan is that none of these things happened. I accept his evidence in that regard. So as we can see, but several failures on the part of the broker. There's a failure to identify any foreseeable risks and to identify what should be the appropriate level of insurance. There's a failure on the part of the broker to advise the plaintiff of what coverage were being placed. There's a failure to examine whether what the exclusions were under the policy that was provided. There's no advice generally given as to what was the insurance provided. So the fact that there was no liability found against the broker in this case is really blind luck. So what do we take away? Bear in mind that the courts see you as trusted advisors. It sees and specifically commented that there's a special relationship between broker and customer, where the broker is providing a specialized knowledge and the customer often relies on the advice that brokers are giving. So there's a duty to become informed about the coverages that are available, about what the customer requires, and to use that knowledge to provide good, considered advice and to help clients reach informed coverage decisions. This next case involves a long-term lease of a truck. In this one, the broker arranged for coverage with insurer A. The intent was to provide the parties with $10 million umbrella coverage for the truck over and above a $1 million policy that existed with a different insurer, O. As luck would have it, the truck was involved in an accident. The insured sued the broker and alleged a failure to provide adequate insurance. The broker, using a procedure called third party process, where essentially the defendant brings in another party and says, it points to the plaintiff and says, look, if I'm liable, that guy's liable to me. So they commenced third party proceedings against insurer A. In the claim against the third party insurer, the broker stated that the intent was to provide a $10 million umbrella policy over and above the existing $1 million policy on the truck. The matter went to summary judgment again. Again, these are methods of avoiding a full trial on claims. The insured was successful and did find liability against the broker. The court refused to allow the broker to withdraw the admission that it did intend to place coverage. And in the course of doing that, it identified, it stated specifically that the broker knew that the truck was not listed in the umbrella policy. He had a duty to advise the insured of the coverage gap. And he had a duty to take all reasonable steps to ensure that there was proper protection for the insured. Most importantly, here is the pitfall for the broker. The court found that it was important that the broker did not have any idea of, in this case, which was a Manitoba case, Section 267.12 of the Insurance Act. That is the same as one section that we have in Nova Scotia, and it exists in every insurance policy or in every insurance act across the country. that the lessor of a vehicle like that truck can't be exposed to anything more than $1 million in third-party liability. So there was no ability to have recourse to any insurance policy, not of the driver lessee of the truck, but its lessor. So any damage, any claim against the lessor would be capped at $1 million. The broker didn't know this. So the lessons. The broker in this case, again, the court commented that the broker did not take the time to look at the lease agreement, didn't take the time to look at the existing policy. And that underlines the necessity of becoming knowledgeable about the customer's circumstances. There's a need to be knowledgeable of what they need, to examine any other documents that might be related to the claim or to the coverages that are being sought, the advice that's being sought, to become informed as to common traps that exist in coverages so that you can properly recommend the right level and the right coverages for the particular circumstances that your customer finds themselves in. This next one is a matter called Ruth Chauvez. It involves a claim where there was an existing policy on a 2008 car. Insured had coverage in place. They later bought a 2010 and asked the broker to move the coverage to the 2010 car. Broker thought for all the world that it had happened. In fact, they issued a liability card. Unfortunately, they didn't submit the paperwork to the insurer. When the customer was involved in an accident with the 2010 car, there was exposure for bodily injury liability. The insurer denied coverage because, of course, the wrong vehicle was placed on the policy and refunded all the premiums that were paid for. The broker's errors and omissions policy paid out the insured's claim. And then what they did is they turned around and sued the insurer. So what happened? That's a process called subrogation, where an insurer steps into the shoes of the insured and pursues a claim that they may be able to advance. So they sued the insurer, the E&O insurer, sued the insurer under the auto policy in tort, contract, and for declaratory relief. The argument that the additional premiums for the 2010 vehicle were only $71 more. The argument was that there was no prejudice in pursuing that claim. And for $71, there is no indication that the insurer would have declined coverage. There was nothing in the facts that would indicate that there would be any prejudice at all to the insurer. That claim was dismissed on summary judgment. Important to note, the brokerage agreement was a full answer in that case to the claim against the insurer. It contained indemnities where the broker indemnified the insured against any claims arising from the broker's negligence. Important to note as well that there is, despite the fact that it would have been with the same insurer, the change from the 2008 vehicle to the 2010 would have been with the same insurer. Despite that, the insurer does not owe a duty to the insured with respect in this regard under these circumstances, except to issue the coverage that was arranged by the broker. And as we know in this case, the broker, because of the broker's errors, no coverage was placed for the vehicle that was involved in the accident. So the takeaway: be detail oriented with respect to the paperwork. Make sure everything gets properly submitted. This next one is a key decision in the maritime region. I would suggest it's the largest and probably the most important claim that's gone to trial and then subsequently to appeal. In this region, in at least a decade. It's called Marsh and Grafton Connor. Involved at Halifax pub was completely destroyed by fire. Key findings of fact. The broker provided the insurer with information regarding the construction of the building. It said that the building was of stone construction. As it turns out, the building was not stone construction, it was mixed stone and wood. The broker indicated that the building was sprinklered. As it turns out, it wasn't sprinklered. The owner knew about the construction of the building, that it was mixed stone and wood, rather, the owner of the building. The owner's manager did not review the renewal applications, but just simply signed them. The broker did not ensure that the owner's manager was knowledgeable about commercial insurance before taking instructions from that manager. Broker did not inquire about the existence of any property inspections, didn't recommend having an inspection done, and didn't conduct any inspection himself. The broker never, as I said, I think the broker did not recommend an inspection. The manager relied entirely on the broker to fill out the renewal application. And that happened year after year, where the insured had an opportunity to ensure that the information in the renewal application was correct, but never did so. The underwriters, as it turns out, would not have insured a mixed construction building with no sprinklers on the same terms that they would have insured a masonry building with sprinklers. So at trial, damages were assessed at $2.7 million for the building, contents, and business interruption. Both broker and the broker and the manager were found equally liable. What did I say here? Sorry, the broker and the owner were found equally liable at trial. The broker had assumed that the owner's manager was experienced, and the company assumed the same. The trial judge would not attribute the owner's knowledge to the company. What the trial judge did in that case is he found that the broker ought to have inquired with the property owner's representative to provide accurate answers on the application. And what the duty to do that would depend on the complexity of the risk, whether or not the information was within the representative's personal knowledge. But on appeal, fortunately, that was reversed. The Court of Appeal found that the trial judge's reasoning would basically require brokers to inquire into the level of knowledge of the people that they're receiving instructions from. Inquire whether they're sophisticated enough to determine things like sprinklering and construction, and that runs contrary to settled law. It amounts to a duty to verify all the information that you receive from a customer, which is it's simply not commercially reasonable. It's not something that's ever been required before this. And it runs contrary to established case law. In this case, the risk wasn't complex, and the complexity of the risk isn't to be confused with the complexity of the property construction. The property owner understood the importance of the construction and the sprinkler into the risk, as did the broker. And there's no special knowledge that was required to answer questions about the application. The trial judge in this case considered that the broker ought to have inquired with the property owner's representatives and about their ability to provide accurate answers. The Court of Appeal said this is problematic. The owner knew about the construction of the property, and to require a broker to look into whether or not the people that they're receiving instructions from are competent to provide those instructions runs contrary to established case law. It's not something, and it goes against established corporate law, which is that the officers of a company, their knowledge is attributed to the company as a whole. The Court of Appeal stated specifically that that a customer has a duty to provide accurate information about the risk. The customer has a duty to read the application and ensure its accuracy. That's something which has been repeated in the case law over and over again. And in this case, that wasn't done since at least 1996. And it's not a defense for a customer to say that he just didn't read the application. Once again, something that's established in the case law over and over again. So what does that give us in terms of takeaway? Overall, this is a very good case for brokers. What it does is it underlines that an insured can't get away with saying that they just didn't read the instructions. There isn't a duty, fortunately, and again, contrary to the trial judge, there isn't a duty to verify the competence of a corporate manager to provide instructions. That said, this was a case which took many years to resolve. It was large dollar. There would have been rounds and rounds of discovery examinations of multiple people within the brokerage. The cost would have been extremely high in terms of time spent and in terms of stress and the loss of productivity just to deal with it. Practice defensively. Consider if there isn't this. Here's the other side of it. If there is an obvious flag that suggests that the person that you're dealing with on behalf of the corporate customer isn't capable of providing you all of the information that in a way that's accurate, there may well be a duty to inquire further. It will not be, despite the finding in this case, it will not be enough to ignore signs that perhaps the person that you're receiving instructions from doesn't have enough knowledge to provide you with accurate information. Ultimately, there is still that duty that's owed to the underwriters to provide accurate information in terms of placing the risk. What I'm going to do next is I'm going to touch on some recent case law. Some of these are cases that happened in more recent years, and we'll kind of see a little bit about how the courts have dealt with these. So this next one's called Siddall and Angus Miller. Now in Siddall, the matter involved it was a jewelry business that obtained commercial instructions from the broker for many years. And over those years, the broker met with the principal of the company on many occasions to review coverage. The policy in this case was issued in October of 2006. It was renewed in October of 2007 and renewed annually after that. And on every renewal, there was a declaration page with the premiums and the details of coverage sent. The plaintiff, and what had happened, just before we get into the loss itself, when the broker received this file in 2008, he ended up keeping the same policy in place. The plaintiff, after the loss, which happened in 2016, said that he thought that there had always been $120,000 coverage for, among other things, the store's stock. As it turns out, there was a quote that the broker provided in 2008 when he got the file, where he noted that there was this gap and recommended jeweler's block coverage for $150,000. Now the premium for that alone would have been $2,495. The customer declined it, but fortunately the quote was on file and there were notes kept. Same matter came up again in 2009. Broker had a conversation with the customer, kept notes on file of the conversation, and said again, and offered the broker the jeweler's block coverage again. Pointed out specifically that in case of theft, there's no coverage except for what up to, or there's no coverage over and above $1,000. Customer declined coverage. The next note on the file is in 2012, so 3 years later. There was a meeting, and at that point, it was the same conversation, but the same coverages were kept in place. And so, of course, in 2016, when the loss occurred, the broker was helped by having a well-padded file. At that point, they brought an application for summary judgment, hoping to dismiss the claim without it going to trial. In response, and perhaps not surprisingly, the insured customer filed an affidavit saying that they had always been careful about coverage, always been careful about insurance and maintaining the insurance in place, that they were more concerned about coverage than cost. And had they known of this gap in coverage, they would have taken steps to rectify it without hesitation. Now, on the file itself and in the broker's affidavit, there was a note stating, in quotes, the agent advised the insured did not want jeweler's block as premiums are too much and will cut into profits. Another note, October 18th, quote was there was a quote requested and signed by the broker offering jeweler's block insurance. On the 27th, 2008, broker prepared a memo stating that, or outlining the coverage. And in the summer, there was another quote provided offering the jeweler's block coverage. In October, there's yet another note on file with the regarding a meeting with the customer, stating that he was only offered $1,000 for loss of jewelry. And he was still considering whether or not to purchase jeweler's block. That was he never called back on that, and jeweler's block was never placed. October 12th, there's a liability survey completed with the customer. Customer confirms, wants to maintain current coverage. That was the response that the plaintiff made was that no, they were consistently advised that jeweler's block was not necessary, not required. When the matter went to summary judgment, it was dismissed, and the broker was found not liable. How? A well-documented file. In this case, the broker was at pains to explain gaps in coverage, quoted the jeweler's block coverage on at least 2 occasions, documented the fact that the principal declined coverages, and there was no indication, most importantly, that the principal would have accepted coverage if it had been offered after 2012, which is a situation that we see frequently, where particular coverage is offered, may or may not be offered again. It's declined on that first offering, declined again, and then the policies are renewed year after year, and sometimes a considerable period of time passes, and lo and behold, there's a loss. And at that point, customer is alleging, well, had I known that there was no coverage and had this gap been brought to my attention, I would have rectified that immediately. The best and perhaps the only way to defeat those types of claims is to have a well-documented file. As we can see in this case, it's not necessary once it's offered, here it was offered on 2 occasions. It may not be necessary to offer coverages for gaps that were previously declined year after year after year. Here, there was a 3-year gap between the last time it was, or rather 4 years, between the last time that it was offered and when we see it again. Sometimes we see that, sometimes we see periods of time go even longer than that. In this case, where the reason for declining coverages was that it would cut into profits, where very clearly from the broker's file, the insured did have a concern about costs. It was defeated and relatively easily. That is not often the case. So where do we go from here with the case like that? Obviously, take the time to meet with the client, take the time to explain coverages, but ensure that the file is well documented. In this case, the court specifically noted that unlike the plaintiff, the broker did have notes and did document their file. So keep a well documented file. Be aware of the situation where you have offered coverages and they've been declined. This case would suggest that it should be done more than once before a loss, in order to avoid liability and loss. Now, whether it needs, clearly it doesn't need to be done on an annual basis, but it should be done at least a couple of times in a row. And then if you decide to leave it for a time, don't leave it for very long. Here, there's 4 years. We're dealing with one now where there's a 10-year gap. The same types of considerations exist as in this case. Will 10 years be enough? Hard to know. In this case, it's there's a 4-year gap, but bring up coverages. Use your prudence and judgment, but bring up coverages from time to time when they've been declined. But if your file is well documented and you're able to meet the argument that the coverage would have been presented if only it had been offered that last time before this last renewal, it will keep you in much better stead. Next matter involves a fire loss where the plaintiff owned multiple properties. In this case is here is somewhat of a contrast to the one that we just looked at. In Alvaro, there's a plaintiff customer owned multiple properties. Shortly before this loss, he advised the broker that he would be evicting a tenant from the property where this loss occurred. But he also said that, look, I'm going to be evicting numerous tenants from all of my other properties as well. I'm going to renovate all of them. And the hope was that he would attract a better quality of tenant. The broker denied that he had gotten this advice. He didn't keep notes, and the customer didn't keep any notes or follow that up with an email or anything like that. Now, the broker said that he did not have any memory of that conversation. Plaintiff said that he had a clear memory of that conversation. And that, if you're sitting in the shoes of the court, kind of makes sense. Broker would have many conversations like that. Would you like this type of coverage? No, I'm good. Or yes, please. With many different customers over a long period of time. Individual claimants, not so much. They typically have very few risks that they're insuring. And so if the plaintiff says, I have a clear recollection of this conversation, and there's no other indication that they may not be believable or truthful, the court will tend to resolve those types of issues against the broker. After all, the court, as we've seen, and as I've said, sees brokers as trusted advisors. So professionals in the true sense, not just salespeople. Professionals keep notes of the advice that they give their clients. So here, the eviction happened on April 16th of 2013. Renovations began immediately. Fire occurred June 3rd of 2013. And the insurer denied coverage, relying on the vacancy exclusion. The broker attempted to try to patch the situation up and tried to convince the underwriter to maybe backdate the application. After all, there wasn't a huge charge. And with respect to any vacancy surcharge, she was certain that the customer would pay it without hesitation. Customer sued in negligence. alleging a failure to place the correct coverage, and failure to advise regarding the vacancy endorsement. Also failing to advise of gaps in coverage. The broker defended, as is very often the argument that we try to make, that on each renewal, we send out documentation that says that there is an obligation to advise of a material change in risk. That's not often discussed, though, with the customer, the fact of the need to report a material change in risk and what might be a material change in risk. And in this case, in fact, plaintiff admitted that he didn't read those materials. As we know, that's not in and of itself a defense. We'll agree with that. It's not a defense. Nevertheless, the broker was found liable. Court stated that it's unrealistic to expect a customer to read through a 54-page document to determine that there is an obligation to report a material change in risk, and or what a material change in risk might be. Court found that the customer is entitled to rely on the broker's expertise to give it the advice of that sort. Advised that it was significant as well that the broker had specific knowledge that the property wasn't a rental, that tenants were going to be evicted, and that it might remain vacant for some time. So despite all of that, the decision, just a couple of clips from the decision itself. Court did say, and these are the findings, despite the fact that the court stated, the authorities which have applied Fletcher confirm that the customer bears a duty to provide accurate information to the broker and to proactively advise the broker when there's a material change in risk. Court also found there's a continuing duty on the client to promptly notify the agent of any material changes in risk, as there is an ongoing obligation on an insured to disclose material facts. In addition to the obligation to provide information on an ongoing basis, defendants and submissive clients have an obligation to review insurance documents. But despite that, the court stated, when renewal documents forwarded do not direct the plaintiffs to do so, rather, sorry, let me back up. Despite any failure of the plaintiffs to read the documents, it's not sufficient for the defendant to rely on that position when the renewal documents forward do not direct the plaintiff to read the documents. And in this case, the only reason for the change was for the policy being sent out was a change in the statutory. And as I said, the court repeated that it's unrealistic to expect the customer to read a 54-page document to find the answer to that question. So again, what are the takeaways? And as always, we go back to what would a reasonable and prudent broker do? The court expects brokers to offer advice that's within their areas of expertise, meaning risks and contracts of insurance that would cover off those risks. The case I suggest points to the duty to recognize the advice giving and counseling role of the broker, and to undertake the proper inquiries and investigations that it requires. Next case also involves a fire loss, a matter called Lung. It's a commercial premises. The loss was $985,000 compared to a $550,000 limit. When presented with the loss, the insurer paid the face value of the policy. And the client sued, alleging a breach of contract and failing to place suitable, affordable, and adequate insurance, which was taken from the website of the broker and also in its advertising materials. They alleged that there was a negligent misrepresentation regarding the adequacy of coverage. Essentially stating that they were assured that $550,000 was an appropriate level of insurance to carry for this particular property. Once again, during meetings with the client, the broker specifically advised that they are not qualified to give expert advice on replacement costs. The client should get expert advice to get and have an assessment done regarding the cost of rebuilding. The matter did go to trial. At trial, both parties tendered expert evidence, and the experts were in agreement that brokers are not qualified to give replacement cost advice. The best practice, both experts agreed, was to advise the client to get expert advice on things like replacement cost, especially where it's a commercial type property and there's the construction and replacement cost might be a complex issue. In this matter, court found that the contractual, when it went to trial, the customer's main argument was that contractual term, that there was a contract where the broker agreed to provide quote unquote adequate insurance. And the fact is that it turned out that the insurance was not adequate. And so they hammered on that point, saying that, well, this was a contract. It doesn't matter about expert evidence. They said that they would provide adequate insurance. This was not adequate. The court said that that term is satisfied when the broker advises the customer to get an accurate valuation. Adequate is not a guarantee of adequacy, and there's no negligent misrepresentation when the broker stated specifically that they're not qualified to assess rebuilding costs. So in this case, we go back to the principles from negligent misrepresentation, whether or not there's a special relationship, whether there was an inaccurate statement. Here, court found that it's not an inaccurate statement because the broker stated that they're not qualified. Even if it was inaccurate, it's not reasonable to rely on that advice because they said specifically that they're not qualified. And so a representation it was not a representation about the ability to offer the advice on replacement costs. In fact, it's specifically not that advice. They were told to go and get advice elsewhere regarding things like replacement costs because it was a more complex issue. So the takeaways that we have from that case, it was significant that the customer was sophisticated. The court found that the customer was a real estate agent and a mortgage broker who had supervised renovations in the past. They were aware that the building, the limit on the policy was increased, the limit on the building was increased to $924,000 in 2008, and that there had been the customer had been involved in a prior loss. So despite that, it was a significant finding that the customer would have understood the difference between the broker's assessment of the rebuild cost and the professional evaluator's assessment of the cost. So hence, the takeaway is recognize the limits of your expertise and the client's expertise. Where appropriate, refer the client out to get independent advice. Things that may be outside of your expertise, those are areas where you should not get involved in guesswork, which really tends to has the potential to expose you to all sorts of liability issues. Next matter is another fire loss on a rental property. That matter involved a policy that had a vacancy exclusion after 30 days. Also, there was a mortgage clause ensuring the mortgage balance. When coverage was initially put in place, there were 2 mortgages on title. Eventually, the customer paid out the second mortgage from a personal line of credit. So in 2006, the insurer contacted the broker because they had found out that the property may have been vacant for some period of time. The broker went back to the customer and asked what was going on. They were told that some tenants had moved out, but some new tenants will be moving in the next month. Why does it matter, they asked. At that point, the only thing the broker said is that the insurance industry believes that it's more likely for a vacant building to be vandalized or damaged by fire. That was it. Eventually, the city boarded the property up after becoming concerned that it was being used by vagrants. As luck would have it, the building was destroyed by fire in 2012, 6 years later. The insurer paid out the first mortgage, declined to pay the personal line of credit because it was not covered. Personal line of credit was not a mortgage. Declined coverage for the remainder of for the rebuild cost because of the vacancy exclusion. Customer sues in negligence. They allege a failure to advise regarding the vacancy exclusion and a failure to advise regarding the lack of coverage for the line of credit. The matter went to summary judgment. The court agreed that the broker can't escape liability by saying that they didn't provide a specific instruction. Broker can't escape liability if the insured fails to read the policy. So in a case like this, it's not enough to say that, well, we weren't specifically instructed to place vacancy coverage. It's in other words, there's a duty there to advise about things like an exclusion, where there's things like a vacancy exclusion on a rental property, where you can expect that the property may well be vacant for some time, potentially more than 30 days, which is typical in those vacancy exclusions. And of course, it's not sufficient to rely on a failure to read the materials that a broker sends out. The broker can't escape liability by saying, well, look, all of this was in the package, and we've seen that repeated in the cases that went before. Here, though, the broker specifically pointed out the obligation to advise about material change risk. Also significant is the fact that the client failed to advise the broker on a number of occasions that the property had been vacant. Failed to advise that it had been vacant for 5 years and it was not even being rented. And in fact, it wasn't even habitable. The policy, of course, excluded coverage for mortgages, and so the broker was found not liable. So what we have here is a well-documented file wins again. But it should be, knowing these cases and knowing our courts and how these things play out, it's significant that there was such an egregious misrepresentation of the facts by the customer in this case. Despite the fact that the broker asked why the building was vacant back when the insurer made that inquiry, the customer essentially lied to the broker and said nothing about it, despite the fact that the building remained vacant for a long period of time. And reading the case, reading a bit between the lines, I would suggest that the favorable result in favor of the broker was probably due in no small part due to the fact that the court took some offense at that. Had the customer not been, or had the customer been more sympathetic, there's a reasonable chance that the broker may have been found liable at the minimum for failing to advise regarding the lack of coverage on the line of credit. Especially pointing out the fact that there the discussion that happened in the last case regarding making customers aware of the duty to report to material change and risk. So in terms of takeaways, point out that what might be material change and risk. Point out the duty to report a material change and risk. Point out that there's an ongoing obligation to advise of changes in risk and what might be a material change. As I said, it's significant that there was such a failure to advise of the change in circumstances in this case. And had that not been the case, the result may well have been different. This might be a good time for a quick reading.
Hi, everybody. So we're going to take another quick break, another 10 minutes. So by my clock, it is 3:46. So if we could come back in 10 minutes, it would be greatly appreciated. And we will wrap up Franco's presentation at that time. Thank you. Hello, everybody. We are just going to get started again in a minute or so. I just wanted to make sure that everyone remains muted. We have had some background noise, but we will commence again in about a minute and a half to 2 minutes. Thank you. Hi, everybody. We are going to start up again. So I guess this is your 30-second warning.
And we're back. All right. A couple of words, I think, before we move into some of the new novel arguments section. In the last little while, I think it's fair to say that the case law has been fairly favorable to brokers. So despite the fact that you are being held to a high standard, it's worth noting that the court tends to be cutting the industry a little bit of slack. I'm saying that, and I want to be cautious even as I say that, in that despite the fact that we kind of see that happening, there's still an obligation to practice defensively, or ensure that your file is well documented, keep notes of meetings. But overall, the last little bit hasn't been terrible in terms of findings of liability where being held to an impossibly high standard. Now, some of the new, at least one novel trend that we've seen in the last little bit. In our office, we've seen two matters where the broker is being sued for failing to place a standard auto policy with sufficient SEF 44 limits. So as you know, SEF 44 endorsement is it's designed to permit recovery against the insured's own insurer for any amounts that they're legally entitled to recover against an uninsured motorist. the limit on an SEF 44 cover, is the same as on the standard auto policy. And what we've seen now, there's two cases where the plaintiff has been in an accident. The at-fault driver did not carry enough insurance to cover off the loss, and so they sued their broker, saying that the plaintiff sued the broker, saying that they ought to have had more coverage against, or a greater standard auto policy limit, so that the SEF 44 coverage would have been higher, so that they would have had that recovery against an insurer as opposed to a defendant who doesn't have the financial wherewithal to handle that sort of a claim, to answer that claim. Now, as I say, we've seen that in two cases. On the whole, our view is that that requires a very high level of reliance by the insured. It's not clear to us that that's something that the broker will necessarily be found liable to provide. It's especially in the two matters that we were dealing with. The policy limits were $1 million. They were about $1 million. And so, with that level of coverage, it's not a slam dunk for either side, but it's concerning. It opens up an avenue of liability against the broker, which no one would have seen even 2 years ago. Nevertheless, be aware, this may be especially in cases where the customer isn't looking for a high policy limit on their standard auto policy. But I would suggest that these days, even a $1 million is just fairly standard. So it may be worthwhile to bring to their attention if they're in an accident against an uninsured motorist who has coverage of if their damages are higher than the other side's policy limits. If their own limits aren't at least as high as the other guys, they may not be able to recover. So, and that may be a conversation worth having. That's what we've seen in terms of new cases, new trends. On an SES, or rather an E&O claim, here are some of the things, some bits of advice. Matt's covered some of this off, and we'll try to offer a few pearls to this as well. Obviously, do not admit liability or pay the claim. You have an insurance policy that does that. It compromises the ability of counsel to defend the claim, and very often your own perspective on whether it's gone wrong or how badly it's gone wrong is skewed because you're involved. Good to have someone who's got some professional distance to take a look at it. So don't admit liability and don't try to settle the claim. Report it to the insurer. Interview everybody that's been involved. Find out who, what, where, when, and why. Prepare a separate file that deals with all of that. What is very useful to counsel is a chronology of events. Yes, we need the standard, the policies themselves for their content in many cases. But what's really helpful is if we know what happened when, so a chronology, and try to construct that as best you can. We will do it as well, but try to construct that as best you can. And that highlights the importance of keeping proper notes, documenting the file, put everything in it. You're better off to have too much in a file than too little. E&O claims are stressful. You will have to prepare a report. At some point, you'll likely be interviewed by the claims examiner or by an adjuster. You're going to need to spend time assembling your file. All of that is a source of stress. Add to that the fact that there will be a meeting, at least a couple of meetings with your lawyer. The fact that the lawyer probably is going to want to examine documents and go over them with you. You will be poked and prodded a little bit gently by your own lawyer and probably more aggressively by the other side. That is the nature of the system of litigation that we have. It's an adversarial system, and it involves quite a bit of back and forth. And that is also going to be a source of stress and something that you need to be prepared for. It's time intensive. Assembling these documents, attending a discovery, attending a trial is time consuming, and it will take up time not only with counsel and with the lawyers and sitting in boardrooms and potentially trial courtrooms, but also time that you're going to spend thinking about the matter and dealing with it internally. That said, once again, a well-documented file helps tremendously. It will minimize the amount of time that you have to spend looking around and collecting documents. Our court system is not known for being fast. It's the nature of litigation. There have been procedures that have been put into place more recently to try and streamline it a bit, but claims still take years to be resolved. I can advise that as of right now, if we were to set a matter down for trial today, we'd be looking at a trial date at the earliest in late 2022. So there are delays in terms of scheduling with lawyers, delays in terms of scheduling with the courts. Your own schedules need to be taken into account. So expect that it's going to be a time-intensive and time-consuming process. Once again, and I hate to come back to the same thing, ensure that your file is well documented. The case law, as you've seen, highlights the fact that a well-documented file potentially is the difference between successful defense and an unsuccessful defense. Copies of the policies, the endorsements, the applications, any client requests should be documented, phone calls, emails, all of that should find its way somewhere into your file. Very often I know there's an electronic file system. Take advantage of it. I should caution you, ensure that you make notes of conversations and meetings, ideally contemporaneously. If it's not possible for some reason to do it contemporaneously, do it within the hour. Because one of the ways that skilled counsel, can cross-examine you on notes that you find in a file is in terms of how long it took you to get that note made and put into the file. As you know, memories fade. So if you have a conversation and then wait a day or two before noting it up and putting it in your file, if that comes out, that's used against you to minimize the effectiveness of having kept the well-documented file in the first place. So when it comes to meeting notes, notes of telephone conversations, do it as quickly as possible. And as always, ensure that everything makes it into your file. Keep notes on things like what you tell clients about the coverages they have and specifically what they don't have. Again, ensure that those are made as quickly as possible and set it out so that you're able to say truthfully at a discovery or at trial that everything you go in, that everything that you tell the client you document, and if it's not documented in the file, it probably didn't happen. But the only way that you can establish that is if it's obvious from looking at your file that you actually do keep notes on everything all the time, and that the notes are always very carefully kept, very carefully made. Document things like customers refusal to follow instructions. If you've recommended a particular level of coverage and they decline that, that should make it in the file in some form as quickly as possible. Don't rely on making mental notes. As we've seen, number one, memories fade. And number two, the courts will tend to resolve differences in the evidence like that, what was said and not said, in favor of the claimant, in favor of the customer. Why? Because number one, if there's looking at them, if there's no tells about credibility, a professional is expected to keep notes. A professional is expected to document their file, because when you go back to look at your file, that informs future decisions. You have many files. Claimants don't. Claimants typically have the matter that they're dealing with. They may be sophisticated and they're familiar with business. They may have a couple, but nothing like the number of files that you'll be handling in the course of your practice. Do not rely on mental notes, for heaven's sake. Keep everything in your file. Ideal is to send out letters confirming advice. We had a conversation on X date. I recommended that you place jeweler's block coverage on your jewelry business. You declined that. If this is incorrect, please advise. When that letter goes ignored, that is evidence on your file, and it shows a particular level of professional competence and diligence. Again, it gives the court every reason to find in your favor as opposed to a claim. Have some sort of a system. Don't rely, if at all possible, on just loose paper or loose notes. There should be some sort of a system documenting the file. The file itself should be neat and organized and understandable. Painful to say that you may be hit by a bus, and then it's the company that's left to defend the claim, which exposes everybody in the company to job loss if it goes over limits. You don't want to be in a situation where the people you work with are unable to defend the claim. Brokers often move away as well, and so it's important that the file should be well documented, neat and organized and understandable, so that the next person who picks up the file can figure out what happened, what advice was given, where matters sit. All right. Fortunately, some would say, well, fortunately, trials are rare. Unless it's small claims court, in which case trials tend to be much more common, simply because the stakes are so low. But in general, these are not claims which are handled in small claims court. In general, these are claims that are handled in the superior courts. And trials are not common. What is more common are dismissals on summary judgment, mediation or ADR, alternative dispute resolution, and that allows both parties to have some control over the outcome of the litigation. In any case of settlement, in general, your consent is required. Ultimately, it's the decision of the insurer to settle, but especially if there's a substantial deductible or if it's within the deductible, your consent will be necessary. In settling files, fault may well be irrelevant. Very often, and it's natural to feel that I didn't do anything wrong. Why are we paying out this claim? Very often, though, the cost of defending the claim can be more than the value of the claim itself. Ultimately, the errors and omissions insurer is in business as well, and so it becomes an economic consideration whether a matter gets settled and whether or not the broker did anything wrong really becomes a side issue. It becomes an economic consideration. Another consideration on settlement I'd like to point out is that there are occasions where the insurer doesn't want its policy wordings to be subjected to judicial interpretation, and so they will start to settle with the claimant. That in turn puts pressure on the broker to settle, and so that also contributes to toward the momentum toward getting claims resolved rather than litigated. Be aware at all times, despite the hopeful trend in recent cases, those types of things like litigation, trends in litigation, are not permanent. They are a pendulum swing. So you'll see things will be lax for a little bit, and then all of a sudden, courts tend to be more stringent and try to hold anyone to a higher standard, not just brokers as a group of professionals. Same applies to any group of professionals where you'll see claims for a time where it seems like the court is taking a bit less of a stringent stance, but that tends to swing the other way as well. So despite what we've seen in the last few cases, Grafton, Connor, which was quite good for the brokerage community, don't expect that to last, and don't rely on it as a trend. Courts are prepared to hold brokers to a very high standard. Some of the older cases, it's almost a standard of perfection. There's a reputational risk that you suffer as well, or you have to take into account as well as things proceed to trial. We can't predict an outcome at trial with certainty. I've said in the past that Justice Safinka, who used to sit on the Supreme Court of Canada some years ago, used to say that on the best case imaginable, there's always a 25% chance of losing, just because a judge might have a bad day. So none of these things can be predicted with certainty. Claimants increasingly are knowledgeable about the duties that brokers owe. I can advise, I've seen on at least a couple of cases where they've specifically said at discovery, oh, well, I told my broker to provide full coverage. And that comes directly out of Fines Flowers. Where do they get Fines Flowers? Well, if you Google it, it's available. So the world is more open and more transparent than it has been. And because of that, claimants tend to come to the courts much better informed than they had been in the past. In addition, we have the added calculus of social media, and they can make life very difficult for a professional who relies on their professional reputation for their livelihood. Overall, though, things are looking up in terms of where we're going with respect to litigation, at least in this jurisdiction. Keep your file well documented, and to borrow from an old TV show, be careful.
Well, thank you to our presenters, and thank you to everyone for taking part in today's session. We will be distributing a survey to all participants. And as noted earlier, if anyone has any questions about the content of the presentations, please feel free to email either Becky Taylor at the New Brunswick Association or myself, Debbie Paul, and we will ensure that you receive a response. I hope everyone enjoyed the session, and I hope you all have a great evening. Thank you so much again. Bye-bye.